For my portion, I do have a PowerPoint. How does the court prefer that I do that?
Well, I think we'd have to get you on the Zoom call so you can share a screen.
Okay. Give me just a moment.
Do you have a link for that?
I do not, Judge, but.
All right, let's see if we can email you that.
Does the government have a paper copy of the PowerPoint that it can share with counsel?
Yes. While I'm waiting on that email.
I don't see the same thing. It's two of everything.
Judge, I'm not seeing that email come through.
Just hold another minute.
For the record. Your Honor, if we're using, I'm sorry, is it all right? I'm sorry, I had knee surgery 2 weeks ago. So troubles. Could we just make the PowerPoint an exhibit if the government's going to use it to the record?
We want to make it an exhibit? That's
Or I would ask
objection here with this S1.
No objection, Your Honor.
All right. And do we have an extra copy for Ms. Smith?
We could share ours. I can share with Mr. Rafferty if they don't have an extra copy, so you can share it.
I did have a copy for the court, but I could convert that to an exhibit if the court prefers.
Sure.
Just write on it. Just write on it. In my stack.
Because I've got the meeting ID, I just don't have the passcode.
Stand by for another email.
I've actually got it right here, Your Honor. Judge, may I go ahead and share screen? Your Honor, I'm just going to quickly move through, of course, the statutory and case law parameters under which Your Honor has to make this decision. 1784A, of course, states that when two or more defendants are jointly indicted, such defendants may be tried jointly or separately in the discretion of the trial court. And our case law, we're relying on Collins versus the state, 312 Georgia 727. Three factors to consider are the likelihood of confusion of the evidence in law, the possibility that evidence against one defendant may be considered against the other defendants, and the presence or absence of antagonistic defenses. And I guess the position of the other side is that neither is saying that three is an issue, that there doesn't seem to be any antagonistic defense. Of course, neither the mere presence of an antagonistic defense nor the possibility that a separate trial will give a defendant better chance of acquittal is sufficient to sever. The defendant bears a burden of showing that a joint trial would be so prejudicial as to amount to a denial of his or her right to due process. So I want to talk about what's not a proper ground for severance first. And this is coming from Mr. Cheeseborough's motion to sever. He says, in sum, there has never been any direct contact or communication between Mr. Cheeseborough and Ms. Powell. Similarly, there is no connection or overlap between the overt acts or the substantive charges associated with Mr. Cheeseborough and Mr. Powell. That is not a defense, and that is not a ground for severance. Similarly, Ms. Powell's motion says that Ms. Powell can receive a fair trial only if she's tried alone. The prejudice that would inure to her from a lengthy trial with any of those she was not involved with, and about the vast number of events she had no knowledge of or connection with, would deny her due process. Again, not a defense, not a ground for severance. But turning to case law, Lowry versus the state, 347 Georgia App 26, a 2018 case. Nothing in Georgia's RICO provisions requires that Lowry, the defendant in that case, have participated in or even been aware of all the alleged acts of racketeering activity committed in connection with the common enterprise. Thompson versus the state, also Georgia Court of Appeals. None of the provisions of the Georgia RICO Act requires that each defendant in an enterprise have full knowledge of all facets and elements of the enterprise and all of its members or actors. And likewise, the federal courts agree. This is an 11th Circuit case, 1996, United States versus Castro. In proving the existence of a single RICO conspiracy, the government does not need to prove that each conspirator agreed with every other conspirator, knew of his fellow conspirators, was aware of all the details of the conspiracy, or contemplated participating in the same related crime. And so we've heard a lot from both defendants about they didn't know the other people. They were located thousands of miles apart. They didn't even know that the other parts of the conspiracy were going on. But the case law is clear that that does not matter. Of course, anytime a person enters into a conspiracy, they are liable for all of the acts of all of their co-conspirators. And that's it. Evidence against one is evidence against all. And as Mr. Wade noted to the court, the state's position is that whether we have one trial or 19 trials, the evidence is exactly the same. The number of witnesses is the same. And so many of the arguments that are made on the other side evaporate. I want to look at the cases that were cited by Mr. Cheeseborough in his motion. Griffin versus the state, that's a case where severance was properly denied. It is not a RICO case. Brown versus the state, Another case where severance was properly denied, not a RICO case. Baker versus the state, severance was properly denied, not a RICO case. Paget, severance properly denied, not a RICO case. Jones versus the state, severance was properly denied, also not a RICO case. Zafiro versus United States, federal case. Again, severance was properly denied. That was not a RICO case. Henderson, which we just received just now, that was also not a RICO case. Severance was properly denied. Mr. Cheeseborough points to a couple of cases in his motion where a conviction was reversed on appeal. And as the court pointed out, in those cases, what the appellate courts found was that at trial, the evidence against one defendant was minimal, almost nothing compared to the evidence against the co-defendants. And so it was just fundamentally unfair that there was all this evidence that applied to one, very little that applied to the other, and the jury may have been confused. Look at defendant Powell's list, and most of these are the same, so I'll click through them. Again, same cases, most of them severance properly denied, none of them a RICO case, and the ones where a conviction was overturned on appeal, again, it came down to insufficient evidence at trial. The evidence against the defendant named was just so minimal compared to the evidence that was pertinent to the other defendants charged. And of course, conspiracy cases, and more specifically, RICO conspiracy cases are different. And that's why we point out that all of those cases relied on by the other side are not RICO cases. And so the analysis is different. The facts are different and the law is different. Looking to our Georgia courts, Pasha versus the state, 273, Georgia Act 788, 2005 case. Each actor in a conspiracy is responsible for the overt actions undertaken by all of the other co-conspirators in furtherance of the conspiracy. Willingham versus the state, Georgia Supreme Court case 1995, where there's sufficient evidence of a common scheme or plan to commit a criminal offense, joinder is authorized. And our federal courts kind of take both of these concepts, and in United States versus Caporale, 806 F. 2nd, 1487, an 11th Circuit case here in Atlanta in 1986, joinder of co-defendants in a count charging a single RICO conspiracy violation is permissible, even if different defendants are charged with different acts of racketeering, if the racketeering acts charged are in furtherance of the overarching RICO conspiracy charge. And in our case, the state's theory of the case and as laid out in the indictment, each and every one of those 161 overt acts charged and all of the offenses charged from count 1 to count 41 were all in furtherance of the same overarching RICO conspiracy, which was to unlawfully affect the outcome of the 2020 election in the state of Georgia. Every single one. I understand the other side's argument that, my client's over here in Coffee County, my client's over here in Wisconsin or wherever sending off emails. But the problem for them is that it doesn't matter because it's all part of the same overarching RICO conspiracy. And the state's theory of the case, as alleged in the indictment, is that as this enterprise operated in multiple states and operated quite a lot in Fulton County, that's why we have this case here in Fulton County, the conspiracy evolved. One thing didn't work, so we move on to the next thing. That thing didn't work, so we move on to the next thing. That thing didn't work, so we move on to the next thing. And that was going on from the first overt act to the last overt act, all part of that same overarching RICO conspiracy. Turning back to the factors that the court needs to look at, and I'm just going to kind of talk about factors 1 and 2, the likelihood of confusion of the evidence and law, and the possibility that evidence against one defendant may be considered against the other defendant. Of course, 3, which the other side agrees is not an issue here. But 1 and 2, because this is a RICO conspiracy case, and because the evidence against one is admissible against all, 1 and 2 evaporate. There's no likelihood of confusion about which evidence applies to which defendant or which law applies to which defendant when all of them are alleged to have engaged in the same conspiracy. And it's significant that in count 1 of the indictment, the RICO count, the allegations set forth in counts 2 through 41 are all included in that count 1. And so while Mr. Cheeseborough may have never been to Coffee County, the evidence about Coffee County is evidence that the enterprise existed and shows that the enterprise was working. And because it's a conspiracy case, Mr. Cheeseborough is liable for what happened there, and it's admissible evidence. Again, going back to our federal court, since any evidentiary spillover, and the court asked about this issue, since any evidentiary spillover is vitiated where the evidence in all events would have been admissible against the movement, in the context of a conspiracy, severance will rarely, if ever, be required. This is a First Circuit Court of Appeals case, and we submit that as persuasive authority here. Again, turning to another example, United States versus Diaz, a Second Circuit case from 1999, and a federal RICO conspiracy case from the Second Circuit involving the Latin Kings. Even when a defendant was implicated in only one of 9 separate murders carried out as part of a pattern of racketeering activity, a joint trial was proper because all of the evidence was admissible against each and every one of the defendants to show multiple things, not just that they committed an act, but to show the existence and nature of the RICO enterprise, and to show a pattern of racketeering activity on the part of each of the RICO defendants, as well as his or her relationship with the enterprise itself. And I just love this quote because I think it sums it up. Again, it's an 8th Circuit Court of Appeals decision, persuasive authority, but there in United States versus Kehoe, the 8th Circuit said that it will be the rare case, if ever, where a trial court should sever the trial of alleged co-conspirators. The other side pointed a little bit to this, but I did want to mention that any potential jury confusion can be addressed by other means other than severance, such as an instruction to the jury to separately consider the evidence as to each defendant. Now, again, the state's position is that because this is a conspiracy case, because it's a RICO conspiracy case, that all of the evidence is admissible against all of the defendants. But even if that, even if there were some issue or to be extra cautious, the court could give a limiting instruction. And the state's position is that it would not be limiting instruction after limiting instruction after limiting instruction, because again, all the evidence is admissible against all the defendants. Also, the defendants completely ignore a long line of cases in Georgia that affirm the denial of severance for Georgia RICO Act violations, all decided under these same principles that I've just talked about. First, Chancey versus the state, Georgia Supreme Court, 256 Georgia 415, a 1986 decision. Evans versus the state.
I think we've got the sites here. We can look at those later.
Sure. And those are provided to counsel, and Your Honor, I have copies of those as well for you. So under these principles, the defendants cannot satisfy the first 2 prongs: likelihood of confusion of the evidence in the law, the possibility that evidence against one may be considered against the other, because that's allowable. That's exactly what a RICO conspiracy case is allowed to do. I don't think I need to talk too much about the 3rd prong because of the statements of the other side. Just would hit that defendant has to show that a joint trial as it relates to the 3rd prong would have to amount to some sort of a denial of a due process right. And we don't believe that's the case here. Palmer versus the state, just to point out a few, Georgia Supreme Court case where the Palmer court highlighted certain situations where there was no antagonistic defense, Barge, Metz, Lauren, and again, won't get into those because of where we're at. But the bottom line there is that it has to be prejudicial as to amount to a denial of his or her right to due process. I also want to talk about public policy. Public policy, and our courts have hit on this issue, strongly disfavors severance in complex conspiracy cases for several reasons. One is judicial economy. There's been arguments on the other side that somehow severing any of these defendants out would be more economical. I'm not quite sure how that works. I think one 4-month trial is shorter than multiple 4-month trials. Same witnesses, same evidence. Minimizing the inconvenience and trauma on victims and witnesses. And I want to remind the court that part of this RICO conspiracy involves victims. There are victims in this case that were targeted by members of the enterprise, and their lives were turned upside down. And that's an important part of this case. And having those people come and testify multiple times over and over would both inconvenience, but more importantly, traumatize them. Consistency of the verdicts. And I've got a little bit of case law that talks about that. Efficient use of state resources and fundamental fairness. Justice Scalia astutely observed, It would impair both the efficiency and the fairness of the criminal justice system to require, in all these cases of joint crimes where incriminating statements exist, that prosecutors bring separate proceedings presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have had the advantage of knowing the prosecution's case beforehand. He goes on to say, joint trials generally serve the interests of justice by avoiding inconsistent verdicts, enabling more accurate assessment of relative culpability. And he points out that these are sometimes advantages that operate to a defendant's benefit. So even apart, he says, from these tactical considerations, joint trials generally serve the interests of justice by avoiding the scandal and inequity of inconsistent verdicts. And our Georgia courts agree. They agree that economic use of resources is an important and legitimate concern. Montgomery versus the state 156, Georgia App 448, a 1980 case. In a case where the same witnesses, the same evidence, and the same charges would be used against all defendants, thus affecting judicial economy in the use of physical facilities, time of witnesses, jurors, and court personnel. The trial court must consider these efficiencies against the possible conflicting interests of joint or multiple defendants. And the 11th Circuit again agrees. United States versus Brown, 2007 decision 505 F 3rd 1229. We find considerations of judicial economy to weigh heavily against severance in light of the substantial systemic interest in handling this complex conspiracy case in one trial. And in that case, it was a 2-month trial. State, as we've represented to you, Judge, believes that this would be at least a 4-month trial. So defendants, the state's position, have not met their burdens as to any of the factors set forth in Collins. The case presents no likelihood of confusion of the evidence or law applicable to any defendant because all of the evidence is applicable to all of the defendants. All of the law is applicable to all of the defendants. And 2, evidence against any defendant may properly be considered against each of the defendants in a RICO conspiracy case, so there's no risk of this spillover effect. Just to mention 3, again, they concede that that's not an issue here. That's all I have, Judge, unless you have any questions.
Just a few. So these, again, the 3 factors, those are just, would you agree that those aren't exclusive?
Yes, Your Honor, absolutely.
All right. So we're really supposed to take into consideration the circumstances of the entire case and anything that just might be present in this case and may not be in others, right?
Yes, Your Honor.
So I guess some of the things I think we need to think through, to me also, it's more this position that we still need to have all 19 people at the table 47 days from now. And maybe this is something, if you need to tag team in with somebody else on the council, one of the first things I kind of want to talk through is potentially how removal affects this. So I know your state is currently litigating this issue with multiple of the co-defendants in federal court. And while that's happening, until a decision is made, we can't issue a judgment of conviction here, right?
Yes, Judge.
Now, no matter how Judge Jones rules, isn't either party going to have the right to appeal that ruling?
That is correct, Judge. Our position is that both sides would have the right to appeal.
And so the 11th Circuit could take any idea of how long to weigh in?
As long as they need to.
Right. So it could potentially even optimistically be a 6-month turnaround just for the 11th Circuit to come up with a decision, right?
Yes, sir.
So if it's a 4-month trial that starts in October, we're potentially sitting at a point where we presented the entire state's case, maybe even the jury has returned a verdict, but we can't enter that judgment of conviction until the 11th Circuit comes to a decision. Is that kind of the scenario we're playing out here?
Judge, I think...
Excuse me, if we could have a moment, Judge.
Your Honor.
And by the way, let me add, I know this wasn't something that I highlighted. So if this is something we need to submit for, post-hearing briefing, we can do that. But this is something that I think is a consideration we ought to be taking into mind.
Sure. And that may be the best route, Judge. our kind of position on that is it depends on what the scope of Judge Jones's order is. If he takes the position that he removes everyone, or that he just removes those who may have, some entitlement to removal, the law is a little unclear on how that works in a criminal case.
But you can see what happened. No matter how he rules, if let's say he says that some aspects of the case stay behind with us here in Fulton County, and the 11th Circuit changes their mind and reverses that entirely and says, no, the entire case has to get removed to federal court. Where does that leave us in the middle of a jury trial? Is double jeopardy attached? Have you now risked your entire prosecution because this case has now been removed to federal court and we've sworn in a jury and it's been presenting evidence against all these other co-defendants?
Judge, again, I think for those very complex kind of fine-tuned details, we may need the opportunity to brief those issues.
It's not easy. And we've got, again, less than 2 months to figure this out. So I think to kind of charge ahead without coming to some thoughts on this very soon might be risky. And then the other issue here is even if we say that the three prongs aren't met, again, just dealing with the logistical issues, the state's case may take 4 months, but voir dire with 19 defense attorneys is going to be a different animal than voir dire with 2. So I don't think saying they're both going to equally be 4 months, no matter how many defendants are involved, would be completely accurate. Is that fair? In terms of who can object, just at any particular question that's asked, the sidebars that are requested, just the sheer physical limitations if one attorney gets sick. Is it really so? Can we so confidently say that each trial is going to be exactly 4 months, no matter who's involved?
I don't think we can say exactly, but I think it kind of cuts both ways, Judge, because if we had, for example, 19 people tried at one time, you have a witness up and let's say they're subject to 19 cross-examinations. Of course, each of those 19 is not going to be the same full length cross-examination. So you would have kind of a shorter, if you took them all together, you might have a shorter time for that witness on the stand with 19 people versus if you have 19 trials of one person. And I'm going to the extremes just to demonstrate the point. But if you have 19 trials with one defendant each, then each of those witnesses would be fully cross-examined 19 times. So there's a give and a take. Some things might take longer, some things would be quicker.
So the other things to think in mind is this is going to be a case with a lot of pretrial motions. And again, I don't know how many hearings we're going to need to have to sort through all those. But if we compress our timeline to 40-something days, our ability to even be able to really weigh those and think through these issues, again, it just seems a bit unrealistic to think that we can handle all 19 in 40-something days. That's my initial reaction. Thinking of just how to get this, and are we even delaying the inevitable? If we say there's no severance, aren't we going to have 17 defense attorneys get up here and file motions for a continuance just saying they're not ready? I think we've already had some counsel indicating they're on trial in other cases in federal court. And if we're just going to be sitting in a position where we're having to consider a continuance motion in 40 days, why delay the inevitable?
Sure, Judge. State's position on that is that we're here on 2 defendants. And so at this juncture, other defendants have filed their motions for severance and they may raise those issues. And it would be appropriate for the court to consider all of these issues in making its decision. But for today's purposes, we're here on 2 defendants. And the issue is, do we pull these 2 defendants out? Not do we pull, defendant 13 out or whatever the case may be. So the state's position is until those are raised by those parties, once we have hearings on those, that they shouldn't affect the court's decision as it relates to these 2 defendants.
Okay, so at a minimum, I think what I'm hearing here is that it might be appropriate at this time to consider whether Mr. Chesbrough and Ms. Powell proceed alone together.
Whether they have provided the court and met their burden to show that they should come out. Not that the other 17 should come out, but they should come out of the pot is the state's position.
Okay. All right. Sure.
Just have like 2 minutes to respond.
Sure. Last word from the defense. This is your motion.
I will take this down just real quick.
Your Honor, I'm not trying to oversimplify this because it is a complicated case, both factually and procedurally. However, as to the 19, Your Honor, there can't be a trial of 19 people, and it has nothing to do with the length of time. It has to do with the fact that 2 defendants exercised their statutory right to a speedy trial, and 17 other defendants, many of whom's lawyers are here, didn't. And that's our right to do, and that's their right to do. So with all due respect, Your Honor, I don't even know that there's truly a reason to spend much time. Of course, I can answer any questions, but really much time talking about 19. So really, I think the question here today, to wrap up, is whether it's a trial of State versus Powell and Chesborough, or 2 trials, one State v. Chesborough, one State v. Powell. All of the cases, and we would like an opportunity, since there will be some post-hearing briefing, to read those cases the court State cited and maybe respond to them. I looked at one. It's the one that says, where there is sufficient evidence of a common scheme or plan to commit a criminal offense, joinder is authorized. Willingham v. State. Joinder is authorized. That doesn't mean that severance is inappropriate. Those are not the same thing. Just because joinder is authorized does not mean the court shouldn't sever. Let me be clear about something, Your Honor. The state wants this case, and I think it's absolutely clear in the pleadings. The state wants a case against Donald Trump and all these people together. The state wants to make this case about Donald Trump. Donald Trump is one of 19 defendants. Ken Chesborough is another one. Ken Chesborough is not a politician. Before 6-7 months ago, he was probably unknown to 99.9999% of the population. You get all those nines? And so now to force him to sit here in a trial where there's evidence of all these other things is just not fair. And I'm sorry, Your Honor. You know, they have a slide here. RICO is different. Sure, it's different. I acknowledge that in my opening. But what this slide does not say is that RICO overrides the rules governing fundamental fairness, constitutional and statutory protection that are designed to protect defendants. This Willingham case, and upon information and belief, I believe most of the other cases cited by the government are cases like murder. The Willingham case is a murder case. It's a murder conspiracy case. Certainly, the state understands the difference between 3 and 4 people being charged with one single conspiracy versus 19 people being charged with 3 or 4 different conspiracies. And Your Honor, if the court were to take the state's arguments at face value, there would almost never, if ever, be a RICO case that can ever be severed. And think about what that means. It means that the state of Georgia and the various district attorneys throughout the state can use the RICO statute, can take 3, 4, 5, 6, 7 different conspiracies, and at their sole discretion, with no oversight by any court, say that they're one, bring them in one indictment, and then we're all stuck together. And quite frankly, Your Honor, let's compare and contrast this to the YSL case going down a few, I don't know if it's floors down or up, I think down. That YSL case, I don't know much about it, but I know enough. I've watched it TV, listened to podcasts. It's a common conspiracy. Yeah, there were different overt acts being done towards the same conspiracy, and therefore the state can try them together, but it's one conspiracy. And that's where I think if you read that Willingham case, where there is sufficient evidence of a common scheme or plan, how, Your Honor, is the plan down in Coffee County, if it's a plan, the alleged plan, have any commonality other than electing Donald Trump, Your Honor? Half of the United States took some act towards electing Donald Trump. If that were the only thing that mattered in terms of connecting all these as a common conspiracy, there would be no rules of due process. And the last thing I'll say, Your Honor, is I will go back to what we said at the beginning. I think it's perfectly clear here that this trial does not have to last 4 months. Because what the state is assuming is that, let's say Your Honor grants our severance motion and allows us to try our case just Chesborough and then Powell separately. Well, they're saying, well, it's all going to be the same evidence. Not necessarily. Obviously, the time hasn't come to file motions in limine, but we will obviously file motions in limine regarding the admissibility of certain evidence, certain extrinsic evidence of other acts that we don't think are relevant. And we have the other motion to sever the counts. And no one motion, I don't think, Your Honor, should be, they all, obviously, I know the court has to rule on all of them independently, but I would argue, Judge, that you should consider them jointly in terms of figuring out the big picture here, which is, it is within the court's control to.
Well, let me clarify something, because I think the argument of the motion to sever the counts really wasn't so much as a ruling on
Yes, Your Honor.
limiting the evidence, just as a logistical, here's the indictment we're going to hand the jury.
And I meant altogether. So if you combine, let's say Your Honor was to grant that, it would be a significantly pared down indictment. Then, assuming that we're going to file motions in limine that kind of track the same type of arguments, right? The things that I know Your Honor is not going to rule on this until we file it, but you might expect that if Your Honor grants a motion that says, all right, these 50 things in the indictment don't get read to the jury, it's probably a pretty good chance either way that we're also going to file a motions in limine to say that evidence of those things that have nothing to do with Mr. Chesborough also can't come in. Your Honor, the bottom line is the state cannot be allowed to call something RICO and the rules are out the window. It wasn't what the General Assembly intended. It's not consistent with just basic principles of due process and fundamental fairness. With that, Your Honor, unless the court has any questions, we appreciate it, and I reserve the remainder of my time to the extent there is any.
Mr. Rafferty?
We've beaten the dead horse as it relates to your discretion about granting a severance between Mr. Chesborough and Ms. Powell. But the first point I made, I think, remains, and that is Ms. Powell has filed a demand for a speedy trial much in the same way as Mr. Chesborough. Many of the defendants, as counsel has indicated in the courtroom here today, their lawyers have filed motions to sever. And I don't think any of the case law or anything that the government has cited here today trumps my client's right to a speedy trial. She has asked for a speedy trial. She filed it timely, just like Mr. Chesborough. Therefore, I think at a minimum, her case is severed from the remaining 17. It must be severed because none of the cases that the government cited point to the idea that all of those considerations trump the statutory rights of my client to a speedy trial. So, we can see what post-briefing comes in about severing Mr. Chesborough from Ms. Powell, but I don't think there's any dispute at this point that Ms. Powell and Mr. Chesborough are severed from the remaining 17 based on our demands for speedy trial.
All right. Thank you, Mr. Rafferty.
Your Honor, just briefly, just for the purpose of the record, I want to make clear that there is a dispute about severing the 2 from the 17. I think the state's made that clear, so I just want to make sure that that's cleared up for the record. There's some statements from the other side. And just before we depart, we would just ask for, if there is briefing, what that briefing schedule looks like.
Of course. No, I think we still have plenty to talk about before we wrap up for today. So obviously, I think has been made clear, we're on an expedited timeline with these statutory speedy trial demands. And we are certainly here ready and willing to provide both defendants that right. And we plan to make that October 23rd trial date stick. With that in mind, I don't know if we're always going to be able to have the luxury of pre-hearing briefing and post-hearing briefing. And some of these issues may require a little more exploration than others. This one, I don't think is one of those. When it comes to the question of whether to sever Ms. Powell and Mr. Chesborough, I certainly agree that there are always guardrails and that RICO as indicted can't just be used to do anything, but it is broadly construed, and those guardrails are found in those 3 factors. And the 3 factors traditionally that we've gone through really don't seem to be at play here. We don't for one, the antagonistic defense issue is conceded. Both parties are going to be claiming they have no idea who the other is and will be pointing the fingers at each other. I think the argument that they're charged in two separate kind of silos of charges strengthens the idea that there won't be confusion amongst the jurors and there won't be spillover evidence. So really the strongest thing that I'm hearing, and I don't think it's invalid, is that it's going to be kind of a matter of inconvenience and potential added expense to have both defendants sit together. And that's certainly true, but there's also other judicial economy aspects to consider and issues of inconvenience as well. We talk about the jurors. I don't think we can take for granted that these would both be two equally 4-month-long trials. I think it could easily be twice that with multiple defendants, and I think we need to take into account the fact that one docket goes entirely on hold while this case is going. And instead of it being, if we're purely considering aspects of judicial economy, which to me was really the only valid argument here, I think taking up 2 dockets and for a period of 4 months also weighs into that, as well as the voir dire process and the inconvenience to the jurors. So based on what's been presented today, I'm not finding that severance from Mr. Chesbro or Powell is necessary to achieve a fair determination of the guilt or innocence for either defendant in this case. And so I'll deny Mr. Chesbro's motions to sever from Ms. Powell. I'll deny in part Ms. Powell's motion to sever from Mr. Chesbro. And the plan will be to enter a scheduling order for Ms. Powell mirroring that of Mr. Chesbro with the October 23rd date holding. It sounds like the state is still sticking to the position that all these defendants should remain, and they want to address some of these removal issues. I'm willing to hear that. I remain very skeptical, but we can. I'm willing to hear what you have to say on it. And so, but again, because we're on a limited time frame, I don't think we have the luxury of waiting. So, how long do you think the state needs to respond to that issue?
2 weeks, Judge?
I don't think we can do that. There's going to be motions deadlines for the other defendants, and we need to get scheduling orders entered.
I had to ask.
That's fine. And I had to deny.
Understood. 10 days?
Well, I think the 10-day mark from today. I know, again, I'm setting the indicator that folks are going to have more than 10 days to file their standard post-arraignment motions. Let's see if we can have that by Tuesday of next week. Again, this is limited to how you think logistically we could possibly keep these defendants together. And I think we can limit that to 10 pages. And if anyone else wants to respond, they can to that issue. But Mr. Grubman?
This is, if you're still going on this issue, I did have a quick other issue just since we have your attention to bring up. We do have a pending motion to talk to the grand jurors.
Right, let me get to that. So again, knowing that Mr. Chesbro and Ms. Powell are hurtling forward and the motions are going to keep coming in, I don't think it makes sense to just have these all pile up. So we would pretty much maybe just keep having these weekly sessions together and handle them one at a time. So to that end, I believe we're starting another trial next week. I think it's a murder trial we're doing next week, but looking at Thursday or Friday of next week, how's everyone's availability? I only saw motions for Mr. Chesbro, so I guess the question's only directed towards Mr. Grubman and Mr. Aurora. Looking at Thursday or Friday morning.
We're here whenever the court instructs us to be.
Got it.
Your Honor, could we ask for Friday morning? I better do a homicide copy of.
On Thursday morning? Thursday afternoon?
No, lawyers say an hour, it's going to be 3, so I just figured we could have, depending on the motion, just squeeze it.
Well, so far you've got, I believe it's the 2 related to the grand jury, and then you have 1 more related to the supremacy clause. Maybe we limit it, since the grand jury issue is something that might take more time to flesh out if it's granted. Maybe we limit it to those 2 for next week, and we can save the constitutional arguments for another day. Can we still do that Thursday morning though? Assuming if it's just those 2 related to the grand jury. That's the plan. Yeah.
I'm sorry, I'm John Floyd. For the record,
Sure.
Thursday morning or Friday morning?
Thursday morning, it sounds like everyone, and we'll do those 2 grand jury motions. And then Mr. Rafferty, if you want to jump on board and adopt them, we can obviously work you in.
Clarification, briefing from the state by Tuesday, is that going to be on the question of whether it's going to be a trial of 19 or a trial of 2?
That's right.
Thank you.
Nothing else from Mr. Chesbro at this time, Your Honor. Thank you.
Okay, thank you, Mr. Grubman. Anything else we should address since we're all here together? Sir, yes, sir.
Some of the lawyers, some of those other defendants or courtrooms may well have interest in the issues and the arguments that the government makes about whether it's a trial of 19 or it's a trial of 2. So are those lawyers make some kind of briefing response to whatever the government says?
I think that would be fine. I think some already have. I think folks have already been submitting severance motions saying that they're not ready, that there are conflicts. And so, that might very well suffice. But certainly I'm not going to foreclose that opportunity if they want to be heard in more detail. So we'll send out an email to everyone indicating as much.
Maybe then on Thursday morning, we potentially have some discussion of that motion as well.
We can. Again, I think by then I'm hoping to have already ruled and issued some scheduling orders because we need to get that clarity so we can focus on what lies ahead. Anything else? Okay. Anything from the state? All right. Thank you all. See you next week.
Thank you, guys.
All right, folks.
Oh, no. Hey, Manny, how are you?
Wait, walk around you.
You can do it in 3 weeks. Yeah.
Good job, brother.